Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Luqmanulhakim Bin Mahzan. My metric number is 1201494. I'm going to talk about the qualification of Peguam Syarie in Shariah Court and the validity of non-Muslim as a Peguam Syarie. Initially, I will brief the introduction part. Next will be discuss the qualification of Syarie lawyer, the validity of a non-Muslim as Syarie lawyer, and case related to the application of non-Muslim as Syarie lawyer. Technically, Peguam Syarie refers to those who practice in Shariah courts in Malaysia and is governed by the respective state Peguam Syarie rules. Peguam Syarie or Shariah lawyer is a person who is given the right by rules enacted by any state to appear and represent his client in every Shariah court case within the confines of such state or federal territories respectively. However, presently, only the state of Selangor provides the definition of Peguam Syarie. As a result, the term remains undefined in other states in Malaysia. Conversely, there are several qualifications to present or apply as a Syarie lawyer before the Shariah court. The qualification of Peguam Syarie, based on Peguam Syarie Rules 1991, a person who first holds a bachelor degree in Sharia which is recognized by Majlis and conferred by Institute of Higher Learning. Second, an advocate and solicitor registered under the LPA 1976. Third, has complete a professional training recognized by the Majlis in the field of Islamic judiciary. 4, knowledgeable in Islamic law. 6, good character and has not been convicted in Malaysia or elsewhere of a member of his profession, and in particular but not limited to an offence involving fraud or dishonesty, and also has not been educated bankrupt. Lastly, a citizen of Malaysia or a permanent resident of Malaysia. The validity of Peguam Syarie as non-Muslim, according to the Rule 10 Clause A of the Peguam Syarie Rules 1993 Federal Territories, the qualification of a Peguam Syarie as provided. First, is a Muslim and has passed the final examination which leads to the certificate of a bachelor's degree in Sharia from any university or any Islamic educational institution recognized by the government of Malaysia. Second, is a Muslim member of the Judicial and Legal Service of the Federation. Lastly, is a Muslim advocate and solicitor enrolled under the Legal Profession Act 1976. In the case of Majlis Agama Islam Wilayah Persekutuan against Victoria Jayasil Martin, the issue is whether a non-Muslim could be admitted as a Peguam Syarie to represent parties in any proceedings before the Shariah Court in Wilayah Persekutuan Kuala Lumpur. The case is regarding to an applicant named Victoria who was a non-Muslim advocate and solicitor, has a diploma holder in Sharia law and practice applied for Peguam Syarie in the Sharia Court. But then her application was rejected because she is not a Muslim and did not fulfill the requirements under the Rule 10 Clause A. Then she brought the High Court for a judicial review, but still her application was dismissed in the Sharia Court. She then made an appeal to the Court of Appeal. The decision of the Court of Appeal state that reversed the ruling of the High Court and declare that Rule 10 is ultra vires the Act 505. It was held the words any person in section 59 Clause 1 of Act 505 must mean any person regardless of his or her religion and does not restrict the meaning to any Muslim. So So in conclusion, Peguam Syarie can be considered as someone's or a person with the right qualification of and fulfill requirements or condition to represent as Syarie lawyer. A non-Muslim may be inapplicant to apply as the Peguam Syarie, but they may fall under the federal court, which based on Islamic concept as a person who has the belief with certainty in Allah and His divine law is one's heart and soul.